Hello and welcome to Health Affairs This Week. I am your host, Jeff Byers. We're recording this on February 5th, 2025. Before we begin, I want to point listeners to the fact that Health Affairs released a new issue this week. It includes 7 articles related to the Vital Directions series in partnership with National Academy of Medicine. One of the authors, Don Berwick, spoke on the Health Policy podcast this week on how to fix the U.S. healthcare system. Check that episode out and order the issue if that's your kind of flavor. We also released a new health policy brief this week titled Implications of Public Policies for LGBTQI plus Population Health in the U.S. Check that out as well. Finally, I wanted to announce an insider event for February 25th. Stacy Ducetsina and Laura Tolan will host a 30-minute virtual event outlining the new drugs at the Medicare negotiating table. The event will feature a 15-minute Q&A session with Stacy and Laura. So if you're interested to ask either of those people a question about drug policy, sign up for that in the show notes. Today, to discuss medical debt, I'm joined by Kinika Young from the Leukemia and Lymphoma Society. Kinika recently wrote an article on Health Affairs Forefront on new federal guidance that puts medical debt collectors on notice. Kinika, welcome to the program.
Thank you for having me. Glad to be here.
Yeah, thanks for joining us. So the CFPB issued a final rule advisory opinion last October on medical debt collections. Can you walk us through that from the top line?
So the advisory opinion provides a reminder to debt collectors, and it clarifies a few key provisions of the Fair Debt Collection Practices Act, specifically as it relates to the collection of medical debt. So the Fair Debt Collection Practices Act is a federal law that requires certain consumer protections and prohibits debt collectors from engaging in unfair or deceptive means when they are collecting a debt. And this advisory opinion does a few things. First, it reminds those who are collecting medical debt that it is, their responsibility to ensure the medical bills are accurate, substantiated, or valid. Unfortunately, we know of consumers who have been harassed to pay bills that they already paid or bills that aren't accurate. So this opinion says practices such as double billing or exceeding legal limits or trying to collect on false or fake charges is a violation of the Fair Debt Collection Practices Act. Second, the opinion suggests some steps debt collectors could take to substantiate the debt before attempting to collect on it, just to make sure that they are complying with the law. Again, these are suggestions, not mandates. And third, it clarifies the term in default, which is not defined in the statute, but it's important for determining when the law applies.
So you wrote about this topic in Forefront. In that article, you noted some debt collectors filed a lawsuit asserting improper rulemaking. So what's the status on that? And is this a direct causation to the removal of the Chevron doctrine?
Well, I'll address the second question first and say the short answer is no. The fall of the Chevron doctrine didn't necessarily prompt this lawsuit. I think the advisory opinion likely would have been challenged regardless of if the Chevron doctrine were in place or not. And so to your first question, in the lawsuit, plaintiffs argued that the advisory opinion is a legislative rule and the agency was required to do notice and comment rulemaking before issuing it. On the other hand, the agency said it is in part an interpretive rule, not a legislative rule, and in part a statement of agency policy. So essentially, it's a guidance document and it doesn't create any new legal obligations. As for the status, the lawsuit is pending in the DC District Court. The plaintiff, which is ACA International, has asked the court to block the advisory opinion from going into effect while the litigation proceeds. The court denied that request, and the advisory opinion went into effect on January 2nd. Right now, the parties are planning to file cross motions for summary judgment, which means they agree there's no need for a trial, and the court can decide the case based on the administrative record and the parties' arguments. And briefing on those cross motions for summary judgment will wrap up in July, and the court's decision will be made sometime after that. Of course, there may be developments happening before then due to the change in administration that would potentially pause this lawsuit or make it go away altogether.
Okay, so a little TBD is what you're saying.
Yes, for sure.
Well, going back to medical debt, can you let the listeners know what is the scope of medical debt in the U.S. today?
Frankly, Americans are drowning in medical debt. It is the leading cause of personal bankruptcy in the U.S. due to the cost of health care as well as the loss of employment that often comes with being sick or injured. And as I mentioned in the article, in the announcement of this advisory opinion, the CFPB noted about 100 million Americans are carrying more than 220 billion with a B dollars in medical debt. The weight of medical debt is significant for many Americans, and it is especially heavy for cancer patients. Researchers recently released a study that showed cancer patients are almost 5 times more likely to file bankruptcy, and their average credit scores are nearly 80 points lower than non-cancer patients. In the patient advocacy community, these are just examples of what we've named financial toxicity. The Leukemia and Lymphoma Society, we hear directly from blood cancer patients who, in addition to fighting for their lives, are having to deal with medical debt. For example, we worked with a patient named Niraj who was diagnosed with lymphoma. Fortunately, he had health insurance that covered his treatment. And despite having out of pocket expenses and having to meet his annual deductible, he was able to make ends meet. But the experience that Niraj went through made him recall a time when he was 15 years old and his father unfortunately passed away from cancer, and his mother continued to receive medical bills for his father's unsuccessful treatment. Another advocate that we've worked with named Christy has a daughter who was diagnosed with leukemia at 17 years old. At the time, the family lived in a small town in Iowa that didn't have pediatric oncology specialists, so they had to travel to get treatment. And the travel expenses, in addition to treatment costs, added up quickly and became overwhelming. Christy ended up having to take out loans, and she drained her 401k retirement account to cover the costs. And it still wasn't enough because the family ended up losing their home. So in the article, I included a link to a 2023 poll that LOS conducted that revealed that nearly 1 in 2 patients with medical debt feel trapped. And I just encourage listeners to check out that poll for more information about, the scope of medical debt here.
Yeah. Medical care is not inexpensive, for sure. And I also was curious, when you talk about the scope of medical debt, are you aware if the scope of medical debt includes medical debt that goes to collectors but shouldn't have gone to collectors? So where like insurance and providers are battling back and forth between paying for costs and where patients get caught up in the middle. Is that included in the scope of medical debt today?
So, in certain situations, yes, that may end up falling to the patients. There was a law passed a couple of years ago called the No Surprises Act, which protects patients in certain situations from being caught in the middle when there's a payment dispute between their insurance plan and their medical provider. But the No Surprises Act only applies to what's called out of network situations. So, that's where a patient receives care unknowingly, most times from an out of network provider. And so the law steps in when there's an emergency situation or other specific scenarios where a patient, through no fault of their own, ends up at an out of network provider. Those disputes are supposed to go to arbitration. Some may fall through the cracks and end up being billed to patients, but there's a phone number that patients can call and information that they can look into to see if their claim should have been sent to the independent dispute resolution process. But that, again, only applies to certain claims, specifically when you get out of network care.
Yeah, I think I was just thought it was interesting. In addition to the financial burdens that a family might face with these sort of issues, they can also take on just resource management issues of like having to take time to figure out what's going on and where to call and that kind of thing. And
Absolutely. Yeah. It's unfortunately, even if you have health insurance, that doesn't mean that you won't be bogged down with, having to deal with out-of-pocket expenses or taking time off work to handle, your not just your medical appointments, but just dealing with the administrative obligations of filing claims and making sure that things are paid properly, et cetera. It can be a lot, especially if you're also sick at the same time.
So you alluded to hurdles posed by a change in the administration, the presidential administration. What are those hurdles? And currently, are there any signals you've seen that suggests where the current administration may go on this front?
Well, a lot has happened since the article was posted, right?
Yeah.
So the president has named U.S. Treasury Secretary Scott Bessent to serve as the agency's interim chief after firing its former director, Rohit Chopra. So with a change in the administration comes a change in perspective and policy and potentially a change in how the agency interprets the laws. So Bessent recently sent a stand down email to all staff earlier this week, instructing them to stop all work on regulations, enforcement actions, investigations, public communications, you name it. They've just been told to stop work. He also ordered CFPB lawyers to stop defending their existing regulations in court, except to seek a delay in ongoing trials. So, as I mentioned in the lawsuit that's been filed to challenge this advisory opinion, I expect to see, some filing in that case to pause the scheduling order that's been entered in that case. Bessent or whoever becomes the permanent director could issue a totally different advisory opinion on this same topic. We don't know. Also, the very existence of the CFPB has been threatened. It survived a challenge previously in which the Supreme Court held that its funding structure doesn't violate the Constitution, but we do expect the agency to continue to come under attack, and we'll likely see a shift towards deregulation. As it relates to medical debt specifically, it's unclear what direction the Bureau could go in, but one might hope that the agency will continue to prioritize helping consumers deal with medical debt, since that would be consistent with the so-called populist platform that the current president campaigned on.
Correct me if I'm wrong, your forefront piece published on January 9th, 2025. Is that correct?
Yes.
Okay, so it was nary a month ago, and a lot has happened. So yeah, thanks for giving that update. Are there any paths to strengthen state laws or consumer protections under the federal law in this area currently?
Yes, I think it's important to know that unless federal law preempts state law on a particular topic, federal law typically sets a floor and not a ceiling. So state law can go above and beyond federal law to do more to protect consumers. There are two federal laws related to medical debt that the CFPB is responsible for implementing. My article focused on one of them, which is the Fair Debt Collection Practices Act. The second one is the Fair Credit Reporting Act. The Bureau has taken the position as recently as January 28th that the preemption of state law is narrow under both of these acts, and the agency sent letters to several state legislatures commending them for pushing legislation that bar medical bills on credit reports. That rule is subject to attack again with the change in administration. And we've heard that there may be efforts to basically invalidate the rule that the CFPB passed regarding that. But here, the Bureau flagged in the advisory opinion that applicable state laws work alongside the Fair Debt Collection Practices Act to govern debt collectors. So specifically, states could define default, since that term isn't defined under the federal law. And, when a consumer has a medical bill that they haven't paid off and they receive calls or letters from a third party attempting to collect on a medical bill, it's reasonable for them to think, this means the debt is in default. So there's an opportunity for states to pass laws that reflect that common sense meaning of that term, so that the protections of the Fair Debt Collection Practices Act will apply regardless of the fate of the CFPB itself.
We've been talking a lot about policy, potential, past, future, present, which has been great. but I'm curious if you have any insights into what there might be any actionable items for consumers in this space if they're facing medical debt. Is there anything that you advise people on to like look into this or et cetera?
Yes, I think it's important for consumers to know their rights in this situation. And thankfully, the CFPB issued a consumer advisory that encourages debtors to pause and review their rights when they hear from a medical debt collector specifically. It acknowledges that these calls can be stressful and medical bills can pile up and make life really challenging when you're also dealing with a health situation. But under the federal law, you do have rights and there are protections available. So this resource from the CFPB, it's helpful to review so you can understand that you may be able to do things like negotiate the amount that you owe, or you can submit a complaint if you feel that you're getting harassing or abusing calls from debt collectors. And there's also some information about getting legal help so you can find an attorney in your state who can help you navigate the situation.
Well, Kinika Young, thanks again for joining the podcast. To you, the listener, if you enjoyed this episode, please send it to the debt collector in your life. Feel free to leave comments in Spotify, give us a rating. It helps people find the show. Send it to a friend. And we hope to see you all next week. Thanks.